Our main client is the Temple Gun Club, and we have several individuals within the Temple Gun Club that are named plaintiffs for us as well. And their claim is the members of the gun club want to be able to own machine guns. And not only that, the club itself has many gunsmiths who know how to convert machine guns that they already own. And we've actually found several of these members have machine guns, have rifles that were made in Texas. Therefore, they haven't been, in this stream of commerce to begin with, that they can turn around and machine in-home into machine guns. Mm-hmm. So that purely intrastate action of converting something that I own into a machine gun is what's at issue in our case.
They have the ability to make that
the ability and the intention and the present intention to do that. However, the federal court, not allowed. Congress has enacted what's called the Hughes Amendment 922-0, which is a blanket ban on machine guns created after 1986. So machine guns that were in existence before 1986 are grandfathered. You can still buy those. They are extremely expensive. But you cannot manufacture except for military or police purposes, and you can't possess machine guns made after 1986.
It's a really weird situation to be in, where the argument is it's not safe for you as a normal, ordinary person to own a machine gun unless it's older.
So the argument isn't that it isn't safe for you to own a machine gun. That's kind of more of a Second Amendment kind of claim. The argument that the federal government makes, and this was made effectively, actually, we are, and we recognize this, stopped in some sense by precedent in a case called Knutson, which is a Fifth Circuit case. And Knutson held that machine guns affect commerce because they are the ultimate product of interstate commerce. And Congress clearly wanted to cap the number of machine guns in commerce at pre-1986 levels. So in other words, this thing is part of commerce. This object, this machine gun is part of commerce. And Congress can regulate this part of commerce by capping it at that specific 1986 level. So at least on its face, this isn't something that the federal government is trying to say, nope, this is too dangerous, you can't have this.
Which would be an exercise of police power.
That would be a blatant exercise of police power.
Which is for states.
Right. The argument is instead, we don't want too many of these floating around in the economy, so we're going to cap this number at 1986
And that's interesting because
levels.
it's not a straight up ban like this distilling law. It's kind of it is a
quasi-ban. Yeah.
But it has a more clever commerce justification, I guess. But it is effectively banned.
Yeah.
Obviously.
So just like the government tried to argue in the distilling case, they can still you can still make it in that one shed, and Judge Jones didn't buy that, but we're just trying to channel the commerce or the activity into things that are easier for us to tax.
Right.
And so in the same way, it's like the Temple Gun Club, the people who are able to machine these guns into machine guns, they're not allowed to engage in that activity. They could go out and buy a totally different weapon that was made before 1986 and comply with the law that way. But if they wanted to just convert their existing firearms into machine guns, they couldn't do that. So that's just a categorical ban on the activity.
In the name of whereas so in McNutt, they're saying this ban indirectly or backwardly facilitates taxation. Here they're saying this ban indirectly facilitates regulation. But there are really three things in truth. There are bans, there are regulations, and there are taxes, and those are actually very different activities.
Yeah.
So without tipping my hand too much, because we are in the process of preparing and filing our answer to the government's motion to dismiss, because their motion to dismiss was quite understandably, Knutson has already ruled on this exact issue, and Knutson is controlling law in your circuit. To which our response is, yeah, we know we're trying to overturn Knutson. That's what we're doing here. Yeah. We were very open about that in our complaint, and we'll continue to be open about that. That's the goal here, is we think Knutson was wrongly decided, and we're going to ask the Fifth Circuit to overturn it. Fun fact, the only way for us to do that in the Fifth Circuit is to get an en banc. So like we were talking about earlier, it doesn't matter really what the panel says. The panel is also bound by something called horizontal stare decisis by Knutson. So they are going to be bound. So we have to bring it in front of the entire court and say, hey, guys, we think that you got this wrong back in, I think, 2007.
Which requires losing at the district court level and then losing again.
Are there interim ways to argue how, this is actually compatible for the time being with Knutson in different ways?
Yes and no. Yeah. So there has been some development in the law. Again, I'm not going to tip my hand too much, but there has been some development in the law since Knutson was decided. Right. So it was decided, I believe, pre-Morrison. So some of that jurisprudence has changed a little bit. And
Morrison is a big, it's one of those big necessary and proper clauses that we were referencing earlier.
Right. And also now we have McNutt, which will be helpful insofar as, like you said, it kind of distills what's already there and shows where Knutson is kind of wrong on this.
Distills, yeah.
Crystallizes.
Dad joke. Let's go.
But yeah, I mean, our argument is just at its core that same necessary and proper clause argument that this is not plainly adapted. And even if it was plainly adapted, this is obviously a function of the police power of government.
Yeah,
this is not a function
the structure
of government. Right. It violates the structure of the Constitution.
I mean, we talked about it a little bit, but like as the lack of limiting principle and how scary that is. Mm-hmm. But also think about if there's a reason we didn't come together at the Constitutional Convention and give the federal government the police power to go across the whole country. We decentralized that, those really sort of life or death situations, encounters between the state and the individual. We decentralized that. That's like the point of the way our system is set up. And then we gave the federal government a few powers, like defend the whole country from outsiders, make sure that our common market is facilitated, and that's about it. But anyway, just think about why this is important. Why we don't want the federal government exercising police power, even if sometimes people think it's a good thing.
On a philosophical level, I think that it is something that we as conservatives like because we like small government, but also it's something that even liberals should like because of that understanding.
It's definitionally liberal. I mean, it's about protecting liberty. Yeah,
it's about protecting liberty. This is something that will protect you, at least in theory. The closer your government is to you, the less likely they are to take your life and liberty without process. So. So all of that to say, we have a lot of important things floating around in the CAF pages right now. I will keep you guys updated on the motion to dismiss, which needs to be filed by next week, I think. And
what are we doing a podcast for?
I know. I think Chance is working on that today, actually. So, Nathan, before we close, do you want to give us a scorecard on McNutt?
Yeah, so the Fifth Circuit, in a unanimous panel opinion, which is just 3 judges, they agree with Judge Jones that the federal home distilling ban that prohibits you from making consumable liquor in your house, that is not constitutional, and that I guess people can engage in I won't give legal advice, but
don't give legal advice.
It appears to be unconstitutional, at least in the Fifth Circuit.
Yeah, it appears to be unconstitutional to ban it for at least the federal government.